regular March meeting of the Planning and Zoning. Excuse me, this is April, isn't it? All right, I'm going to start out by asking for indulgence from everyone. This is the first meeting I have chaired as vice chair. So, newly elected vice chair, and now our chairwoman is ill, so I get to chair the meeting. My first order of business on the agenda is call to order and invite any one of the commission to make the opening invocation. Anyone willing to do that?
I'll do that, sure.
Sam?
Let us pray, folks. We have this opportunity in a family way in the activities of the community, involvement with the safety activities, the fire activities, the police activities. It's part of what we do as a growing element in the world that we live. We share our ideas, we share our grades, we share our benefits. We ask the Lord to follow, to guide us, to lead us in these types of decisions and activities. Amen.
Amen. All right, thank you. Thanks, Sam. The next order of business is the approval of the minutes. You should all have a copy of the minutes in your package. Is there anything that we need to consider or any changes?
I have a minor change that I was curious about. We refer to in the minutes on the second and third page, if I remember reading them correctly, code, we use an abbreviation in there. See what, zone in the section G.1 advisory committee report, down one of the bullet points, and the current language ordinance per zone CO. Is that supposed to be CODE, or what is a CO?
That's the company that did the audit of the zoning ordinance. And so that's the company who gave us recommendations about amendment.
I don't misunderstand it, but the meeting minutes, could we actually add a longer name then to make sure it's not misunderstood? I read it initially thinking it was the zoning code, but that's a company, right? Per ZO.
Right, and the company's name is Zone Co.
Zone code?
I
Yeah,
think,
capital Z-O-N-E, capital C-O. So it's the name of a business.
That is the official company's name.
How about we change it to capital letters then, ZO? That's it, the name?
That's the official name, yeah.
Can we add another clarification?
Per our consultant, zone
Yeah.
code.
Yeah, something like
okay.
that.
That's good.
You'll find that on both the second and third page.
Okay, I'll add those.
Thank you.
Thanks for catching that. All right, I'll entertain a motion to approve the minutes with that amendment.
So moved. Second?
Second, all those in favor? Approved as amended. And then we move to the financial report.
Yeah, if you look in your packet, you've got 3 pages, 11 by 18 pages. We're just going to be talking to the very first one. Well, at least I got, 8 by 11 by 18. So we'll just be talking to the first one, which is our ordinary income and expense page. There'll be, there's 4 columns there that we may be referencing. The second one in is the first one in is the March monthly column. The second one is our year-to-date expenditures. The middle column is the preliminary budget. This is what we refer to as budget all year. And then the 5th column is the budget amendment, the 4th column, budget amendment, which we approved a couple months ago. And then the percent of budget on the far right, that's actually percent of budget amendment. Okay? And so first we'll just quickly talk about income. And if you go down to, it's about 1/4 of the way down the page, total commission revenue. You can see our total commission revenue to date is $187,932. That's in the second column compared to our original budget of $194,280, compared to the revised budget amendment, and these are total year numbers, the last column, $231,792. And that says that we're at 97% of the budget amendment. That number's wrong. It should be 81%. So that 97% should be 81%. And if this was a normal budget, and if we were right on budget, since this is the 9th month, we'd be at 75%. And so we're stronger than our budget amendment had us being at this time of year. And again, that's because we had the extra revenue from Danville and Boyle County carried over from the prior year. Not much more to talk about, except down on the bottom of the page, when you look at expenditures, very, very bottom, you'll see that our year-to-date is $218,903 compared to a budget of $230 for a total year, compared to a total year budget amendment of $301,000. So we're at 73% of expenditures. So we're below our target expenditures, and we're a little above on the revenue side. And the only other thing I would comment is if you flip the page over, just the first page, and if you look at the orange highlighted table, the table that's got the highlighted orange line item, under total capital items and reserves, you'll see $40,080, $40,080. That's what our budget amendment is projecting our end-of-the-year cash balance to be. The reason that is important is several years ago, Planning and Zoning, at the recommendation of the Budget Committee, agreed that if that number, when we do our formal budget in a couple months, if that number is ever forecasted to be below $40,000, we will then go back to the city and county and saying we need a revenue increase for the year. We've never asked for, well, at least 12 years, we've never asked for a revenue increase. But when we do the budget a month or two from now, if the number that Hannah forecasts our ending balance to be is below $40,000, then that triggers us talking about having to go back to the city and county for the upcoming budget year.
Right.
And ask for an increase from the $75,000 per group that we ask for now. So just keep that number in mind.
We're right at the edge, is what you're telling us.
Yes, we're right at the edge.
I'd like to look at the other way. We're right where we want to be.
So we do need to approve the financials.
Director, is there any other expense that you're expecting here that might show up here as a bigger expense?
The only relatively new big expense was that iWork subscription, but it was a one-time expense of $6,000, and that will only be a one-time expense annually. And that was to connect with the county and the city on a database online for streamlining permitting processes. So no, I don't see another big expense
Okay.
between now and then.
Thank you.
Any other questions? No? I'll entertain a motion to approve.
I make a motion to approve, please.
Second. All those in favor? Thank you. All right. When we move on to construction sureties, Hannah, you're going to
Yes.
walk us through?
Yes, so we got two things on the agenda today. The first thing is Boyle County Industrial Foundation has requested the full release of their letter of credit of $796,130 because they do not plan to build the road now or in the foreseeable future. And it's highlighted on the top, so the total letters of credit after the release would be $2,722,750 or $750.45. And yeah, like I said, JJ reached out and said they do not plan to build that road. They have extended it past the 5-year in hopes that they would eventually build that, but they don't plan to do that anymore.
They don't plan. All right.
And then sorry, do we want to do a motion?
Go ahead. Do we want to do each one separately, or I think you can?
Separately.
Group them. Oh,
Hannah.
separately.
Yeah.
If they do come back, they've said now that they don't intend to do that road, so they'd like that surety release of them. If they do come back at some point, there's a change of mind in 6 months or in a year, and they do want to do that road, what's our process for getting that surety back?
I believe the process would be to start over again, given that they've extended it into year 5, and we don't typically allow extensions over 3 years, but I will refer to Henry on that process.
Hannah, did we talk about an amended plat for this that might
Yes.
remove?
Yes,
the road?
yeah.
So
So they are still planning on filing an amended plat to make sure that road is not recorded at the deed room. So,
And so then if they had a change of mind, they would have to put it back on the plat. And at that point, as part of the approval process, we would require posting a surety.
Okay. All right. So we're going to do each separately?
Yes.
I'll entertain a motion to,
Mr. Chairman, I have to recuse myself from the first one, if you would.
from the first?
Yes.
Yes. All right, with that, is there someone willing to make a motion to release the surety for the BCIF?
Mr. Chairman, I'd like to make a motion to do that, to release that money.
All right, do I have a second?
Second.
All those in favor? All right, and recorded with the recusal. All right, then
All
Hannah.
right. Next one on the agenda is Peeler Moving and Storage Southtown Street has granted the full release of their cash bond of $12,416.80 to the city of Danville to complete the paving of their site plan. And I've been in contact with them about this. So if y'all have any questions about this.
Any questions? Questions, anyone? Comments? All right, we'll have a motion to accept the release. Anyone moving that?
So moved.
Second, and all those in favor? All right, approved.
All right, and I actually did want to touch on the one performance bond. I think last month we talked about having Danville host Center Estates on this agenda. We did a site visit, but performance bonds can only be released in full. So we are just waiting to hear back from the owner to do a second site visit, and then hopefully that will be back next month as well.
All right, very good, thank you. For next month's agenda.
Yes, yeah.
All right, we're moving to subdivision approvals. JMax LLC has applied for a subdivision of 5.507 acre parcel of land into 7 tracts on 101 Colonial Way, Danville. The property is split zoned, single-family residential and multifamily residential. So the Planning Commission gets to consider this item and to see whether it is technically correct and make a decision based on that. I think there have been some discussions prior to this meeting about how we will proceed here. Henry, do you want to comment at this point?
Yes, please, Mr. Chair. So the first, you've said that this is a matter that we look at for whether it's technically correct. That is true. There was a statute that passed last year which said that subregs, in order to be effective and valid, must have objective standards for approval of these things. In other words, you can't leave it up to the Planning Commission and say, approve if you like it, disapprove if you don't. The standards have to be technical, objective, and if it's correct, then it's a ministerial act and we have to approve it. There have been issues raised about this which have to do with deed restrictions, and that raises another question. Where these things are technically correct or ministerial for approval, they're not required to have public hearing. And that's why we list it that way on the agenda, that it's not a public hearing matter. At the same time, there have been occasions in the past when we did allow comment on plats. There have been court cases where even for non-public hearing items, the courts have scrutinized whether due process was given and a chance to comment on them. And I know there are people who want to speak today. I know there are attorneys who want to speak. And I would suggest to the commission that it could be appropriate in this case to allow public comment about it within reason. I don't think there's any need to have redundant comments, but I think it could be appropriate in this case if the commission decides to do so to have public comment after the applicant has presented the plat.
Thank
I
you.
think there might be other legal issues that weigh into this, and I will reserve any comment on those for questions or anything that's brought up during public comment.
All right, very good. Thank you, Henry. So I think,
Do we do the public comment first, or do we
I
do some technical review first?
I think it's typical for any presentation that our staff has, and then for the applicant to speak to it, and then
right, I
public comment.
think we will proceed in that order.
Yeah.
So unless the commission has a concern, at this point, I'll take a motion to go into public hearing, which we would not be required to do, but we are going to do this morning, and consider that motion. So is someone willing to make that motion?
I'll make a motion to go to public hearing.
All right, very good. And second? All right. All those in favor? Very good. So we are now in public hearing, and we'll open the floor first for the staff comments. So Hannah, if you would lead us through the application and what we're seeing.
Sure. So this is the plat that you have in your files right now. So JMX LLC has applied for the subdivision of a 5.507 acre parcel of land into 7 tracts known as 101 Colonial Way. The property is split zoned, single-family residential and multifamily residential. During tech review, I'm going to show you a separate image and then show you kind of the vicinity map as well. But this kind of gives you an idea of where it's at and how these tracts would be separated. And then this is the purpose statement for that plat and the vicinity map as well. During tech review, some of the comments, well, there were really not a lot of concerns during tech review, but we did discuss the split zoning. And it was conveyed that the owner and the surveyor want to do R1A structures and abide by that. But I believe that was the only comment during tech review and concern from staff at this time.
And for the rest of the commission, are we all okay with the location of this? Do we need to go back here for a second? So just orienting where the property is and what we're considering. You guys okay?
Well, just for clarification then for the public, it's, although it was split zone, it sounds like the owner has agreed that it's gonna be residential only.
Correct,
R1A.
yes,
There
yes.
won't be multifamily, it's just gonna be residential.
Right.
Single-family residential.
All right. So with that, thank you, Hannah. I'll first ask for comments from the tech review. So were there any issues from the tech review committee that might speak to what we're talking about here?
No, Hannah did a good job. I was at that tech review. Hannah did a very good job of representing what we had. Very minor comments were made on the paperwork. All right. So it reflects what was presented.
Okay. Any other questions from commission?
Have we found any covenants or deed restrictions on this property?
They have been submitted to you, I believe, are those restrictions before you this morning in your packet. And those are, as we've discussed before, a private contract. They are not something which this commission is responsible for enforcing. They're a matter for neighborhood enforcement. There is statutory authority for when there are standards more restrictive than our own, we're required to adopt the most restrictive standard. However, the way that usually comes into play is if there is something in the neighborhood restrictions which requires certain setbacks, where those diverge from our zoning ordinance, we have to follow the neighborhood's more restrictive setbacks. I think that's not the nature of the restrictions being put before you this morning.
All right.
So you're, what I hear is that the plat that we have on here doesn't need any additions or corrections because of this.
The engineer can speak to this. I think that there have been additions to the plat that might be reflected on the copy you have now that address these restrictions.
Okay.
And let me offer another disclaimer, which is that since these restrictions are not something which the Planning Commission is responsible for enforcing, I am not here to advise you this morning on their legal validity and whether they are still applicable. I have no reason to doubt that they are. I just have not done a title search or anything like that.
Okay, thank you.
All right, so with that, we'll ask for comments from those in favor. Oh, excuse me,
Shouldn't we have the surveyor?
the surveyor.
That's putting this forward should come up and speak.
Yeah, thank you. And if you would, state your name and address.
Colt McGlone, Vantage Engineering, 2038 Danville Road. We are working for JMax LLC. So the only thing I would like to say about the covenants as far as setbacks, it does say in deed book 506, page 188, that we are to follow the setbacks laid out in an earlier plat that created a lot of Williamsburg green. So that 35-foot front yard building setback is displayed on there, and that is a plat and setback, not your all standard setback's 25 foot. So that is something that's increased that we're abiding by. The only other thing, I guess, that has been brought to our attention, and we added a note, there's additional items in deed book 506, page 188. We don't have a title report. An attorney hasn't given us one, but we have made a note to the plat that says the lots created by this plat may be bound by restricted deed provisions set forth in deed book 506, page 188. Any buyer is advised to consult with legal counsel. So we wanted to make sure that we addressed that and it wasn't, misleading anyone at the time.
You added it since the technique.
Yes, sir.
Okay.
Yeah. And I emailed a copy of that plat. I don't know if it was, okay. I was about to say, I don't know if you have that note. Is there any further questions?
Anyone with further questions?
What was the major restriction that you saw that you're proposing 1, 2, 3, 4, 5, 6, 7, is that correct?
Yes, we are turning what was known as Track A on plat file 1841, and then it was subdivided in 1909B further. So we are proposing to turn Track A into 7 lots instead of 1.
Was there a restriction on how many that could be turned into previously?
So in deed book 506, 188, it lists a bunch of restrictions. I didn't see anything. Like I said, I'm not an attorney. I didn't see anything that says you can't subdivide it. There is a note about how many residential houses can be built on it. I think it referred to it as parcel 2, but it's the same property.
What was that note and how many did it say could be built on there?
One house.
Yeah.
Have the deed here. It says one house and there's a limited square footage on it.
Yes.
How do you propose to legally get around that?
I'm not the developer, I'm just the surveyor. I was hired and requested to create the lots. Like I said, I was not provided a title report, but it didn't seem like there was anything wrong with what we've done survey-wise. So that's why I've added the note. I don't want to mislead anybody, but we've
Is
just
the
performed the
developer-
survey as hired.
Is the developer here with you to speak to that?
No, sir, he is not.
All right, thank you. Other questions or comments?
Just a reminder to commissioners to have microphones on when you speak, please.
Yes.
Okay, so for our staff, do we understand that to be the case, that the deed was for one dwelling on that property?
It does show that. The language is further, not more than one residential unit shall be erected on parcel 2. And that's what's stated in the deed. What you're approving this morning is not a building permit for a dwelling, and it does not necessarily effectuate dwellings. I think it's reasonable to contemplate that possibility, but what's happening this morning is not the creation of a dwelling, it's the creation of lots. Theoretically, could it be used for just things that are conveyed but not built houses upon? Yes, theoretically it could, even if that's not likely.
But that whole issue, if I understand correctly, is a separate issue.
It is, yes, sir.
Yes.
Why would we go down that road of allowing the lots to be broken up with the intent of putting houses on there if they can't put houses on there? Can we do that?
Unless council present this morning show otherwise. I don't see anything which prohibits subdivision. The prohibition is on the building of houses.
Okay.
And I,
Are these quarter acre lots congruent with similar housing in the area? I mean,
well, across the street
does
is,
everybody else have 5 acre lots? And so
across
this
the
would be a
street
5 acre
from
lot?
Colonial Way, from these lots, it is zoned RM3, but the rest of the neighborhood is zoned R1A, single family. So this cul-de-sac, the houses across the street are zoned RM3 currently. And I also do want to mention that because, and correct me if I'm wrong, Henry, because this is still a subdivision approval, I just want to make sure that we, like, if it's technically correct, do we have to approve it?
Yes.
But the similar houses, say on Graybrook and Colonial Way and Seminole, those are all relatively, or they're probably quarter acre, maybe half acre
I
lots.
would believe so. I can look it up right now, but they are zoned RM3, but I think they conform to the R1A district. So
Okay.
they would be similar, yes.
Okay.
Yeah.
I just,
Yeah.
so this would be different in my mind if everybody else had a 5 acre lot.
Right,
And you were
yeah.
looking at putting a chunk of homes in there that are on quarter acre lots, that would be vastly different. If this area is full of the smaller lot sizes, then this is really adding a small proportion of the overall homes in the area. And they would, as I'm looking at this, I would assume that single-family homes, 1,500 square feet, the exposed, following all of the other deed restrictions. So the intent would be, these could be used to build homes that are similar to all the other homes that are in that area.
I think it's very similar to the character of the neighborhood.
All right, thank you. Questions and any other questions or comments there? With that, I think we want to open for public input. And I'll ask folks to please, if you can, limit yourselves to comments that are different than anyone else. So we will accept comments from everyone. And your lawyer will speak first, I'm sure.
You've seen, excuse me, enough of me to know.
And I'm not going to chide you for being brief, like Ms. Davenport would, but I would
Thank
ask
you, sir.
to hold your comment to relevant.
I completely understand. So, as you all know, I am,
You want to introduce yourself
Yes,
for
yes,
record?
that's what I am Melanie Thornberry. I am an attorney here in Danville. And I also, in full disclosure, do live in this subdivision, just in a different section of this subdivision. I was contacted by neighbors who do own a lot in Section 6, which is the subject of what you have in front of you, and they certainly have the standing to take all legal steps necessary to enforce the proper use and development of property in the neighborhood. I did send to you all yesterday, and it should be in your packet, a letter setting out the problem with the proposed, excuse me, I'm still trying to get used to reading glasses, with the proposal that is pending in front of you. Based on the comments that I have heard this morning and very good questions of some commissioners, I want to address a couple of these things out of order that I did not address in the letter, because the letter is focused solely on the fact that this area, this particular parcel, is subject to a very specific restriction that everything that encompasses and makes up Tract A, which is a 5.294 acre tract, is limited to only one residential unit. Tract A in its entirety is the subject of the proposed subdivision of JMAX. There is, between the history of the plats of record for this area, specifically Section 6, as well as some legal basis, as well as our ordinances and flume here, there is, in my opinion, legal opinion, a correct conclusion to be reached that Tract A cannot be subdivided as proposed by the applicant. But, as Mr. Smith noted, he's not here to give you all that legal advice, and I don't think any of you are attorneys. But it's a legal determination that ought not be made by Planning and Zoning Commission. Further, as to a technical review of this, the plat that was presented at technical review, I am assuming, is the plat that was attached to the application filed. That plat made no mention of the private restrictions that are on this property. The subdivision regulations that this body adopted in, I believe it was October of 2025, specifically requires, and I quote, and this is at the bottom of the first page of my letter, pursuant to Section 1.9 of this commission's subdivision regulations, in case of conflict between this ordinance, being your subdivision regulations, or any part thereof, and the whole or part of any existing or future ordinance of the applicable jurisdictions, or the whole or part of any existing or future private covenants or deeds, the most restrictive shall apply in all cases. That has been adopted by you all in your subdivision regulations, and therefore the plat that was before you at technical review failed to disclose, as is also required, I think, in Section 4 of your subdivision regulations, and again in another section, that any proposed subdivision must disclose private restrictions that could affect the proposal. My point in that is that the plat that was before the technical review was incorrect, and the application itself was misleading because it failed to disclose that which it is required to disclose under your own regulations, and therefore the plat that has been put before you today with the amendment of the plat note ought to go back to technical review and go through that process again. Excuse me. Mr. Ruby had some very good questions that I think I have touched on, which is that to subdivide, to allow the subdivision of Tract A is a violation of the private restriction. Should not be done. Further, there has been mention of this split zone out there. And I have looked at the zoning map online. I have not looked at the official map that is here in the Planning and Zoning office. But when there is a split zone, it is not proper to allow the more lenient or the larger encompassing zone to be applied when there is a narrower, more limiting one. Again, that legal concept that you all are familiar with of the more restrictive shall apply, not the less restrictive. So there is a question, and I would say there is a necessity for this proposal to be before you all, that the applicant should first have filed and pursued a zone change to demonstrate which zone it is that he proposes to proceed under for his proposed subdivision. I appreciate that apparently at a technical review meeting, the applicant and/or his surveyor indicated what his intention was. But as you all have heard me say before, intention does not matter. Intention holds no weight, and intention is not enforceable. The only way for this to be done fairly for all parties is there is a split zone. I have appeared before on zone changes for split zones to determine which zone any use or development of the property is going to proceed under. And it would be at that time that you all could have a public hearing and hear from all parties who are interested in this matter. And it would also give the opportunity for things to be addressed and history given as to how this split zoning arose, because it's an oddity that has happened across the county. And I've now been practicing long enough to remember when a prior zoning director and one member of the zoning commission went through and designated zones that had been one thing under a prior ordinance into what they believed it would translate to under the new, which again is zone change that was not properly heard through the process. I'm looking at my notes to make sure I've touched on the things I wanted to touch on. So, in conclusion, I guess I would say first and foremost, I think there is a zoning issue, and therefore this plat approval cannot be addressed because you do not know under what zone this is being sought. And two, technical review was not correct, or excuse me, technical review was not done with the correct plat because the one that was presented to you, I think yesterday, and I got a copy of this morning, contains required information that was not previously there. And the application also was not correct. And those are matters under your own subdivision regulations.
Have you seen the amended plat this morning?
I did see it this morning.
And does that amendment address the comment that you, or the concern that you had?
Well, that amendment states exactly what Mr. McClone read into the record. You're asking me to read small print here.
Sorry.
That's okay. In that he references that this tract may be bound by restrictive deed provisions. It cites the deed book and page number, and then also states that buyers are advised to consult with counsel about the provisions of that deed. That is the deed that I attached to my letter to you all, the first deed. That does specifically state that all of Tract A, being the 5.294 acres, is restricted very specifically to not more than one residential unit. What you have in front of you uses a very small part of the entirety of Tract A to produce 6 separate lots. And I think, if my reading of that is correct, it already shows a footprint area for units inside of those lot lines. And then remaining is little over 3 acres of that Tract A, which is where the surveyor gets these 7 parcels into which this purports to divide it.
We probably can ask the engineer about that footprint if you want to.
Do you all have any other?
Do we have any other questions?
So according to the deed 506, page 188, page 1, and kind of looking at the duration of the restrictions on page 5, the only person that can change the duration of this restriction for one building on parcel 2 is the Meadows Partnership? Or would?
Yes, so it says there, number
So-
15 is what you're looking at. But let me point out to, for the benefit of everyone first, that the duration of these restrictions shall run with the land for a period of 20 years from the date of the deed, which is
2014.
2014. And then, at the end of that 20-year period, the restrictions shall automatically renew for successive 10-year periods. Under case law, and sometimes under individual private restrictions, it will allow an attorney and/or a judge to determine at what point typically a majority of property owners within a section can amend, change, or terminate restrictions. And
Okay,
the
so-
sentence that you're looking at is that final one that says that these may be amended in whole or in part by unanimous vote of the partnership without the concurrence of the owner, which would be the owner of parcel 1 and parcel 2 described in that deed, being lot 17 and tract A. Graybrook Meadows is no longer a partnership. Graybrook Meadows converted under statute to be a limited liability company. I know the members of that, and one can find that information on the Secretary of State website and where they are, and, you know, if something is needed by this commission from it. But at this point, the restriction that is there is in place and effective.
Sure, but if that were to be changed, if the owner wanted to square this away, that partnership or whoever's in
That
charge of that.
owner would
that
need
owner would be
to,
able do that.
J-Max would need to
Get the unanimous
approach
vote.
and get the unanimous vote of the now LLC that
Okay.
placed the restrictions on this property.
Okay,
After the 20-year period.
After
At
the
any time, right?
20-year period, yes, they're going to renew for, automatically renew
Guess
for
what I'm getting
successive
at is
10.
Do they have the opportunity to do that inside that 20-year period? Can they go to the neighborhood LLC and ask for a relief of that deed now?
That is an excellent question, and I'm going to give you such a lawyer answer that you're going to dislike me for it.
Don't say it depends, please.
Well, it does depend. And the reason I say that is because I have not undertaken to do the legal research on the case law in Kentucky that would be applicable to that excellent legal
I
question.
just like it says shall, and that means something.
Right, it does. It absolutely, shall, under your all's own ordinances, as you define it, means something very important.
Yes.
And in the legal world, the definition of shall is also extremely important. It is not ambiguous. It does not leave wiggle room.
But to the points that you've made earlier, all of that is not relevant to the issue in front of the planning commission. We need to consider whether this plat is appropriate or not.
Well, so let me,
And
you're
you've
getting
given-
exactly
you've
where I
given
was.
us a couple of excellent points to consider. I think I'd like to make sure that we get comments from the public if we could.
Yes. If I can, though, let me end on this. To your point, and I think this also ties in with Mr. Ruby's questions. It would be that what is in front of you today for a final step in approval process is seeking approval on a plat that was not technically correct and should not therefore be on the table for that final approval today. And when it is sent back to technical review under the plat that they submitted yesterday with that additional note, I think that the application also needs to be revised, because under your subdivision regulations, that application is supposed to state the private restrictions that are here. And then, when it gets to technical review, I would say that, or perhaps this is better at the application process, that because you're dealing with a split zone, you have a zoning question. And that zoning question is only properly addressed by a correct and proper zone change application, where the property owner makes clear under which zone it is that he intends to proceed, so that the property is correctly bound by a zone. And then it is in front of the Planning and Zoning Commission at the public hearing on that zone change application that there can be a hearing where attorneys and public can address whether they support or disagree with the zone change, because your flume that you recently adopted factors into a zone change. And there's a lot I could say about the flume on this particular piece of property, but I'll spare you because we're not at a zone change hearing.
All right.
Yes, sir.
Thank you.
Can I ask you your personal legal opinion on this question? The surveyor said into the record this morning that his client intends to abide by the R1A single-family zone. Is that sufficient enough to hold their feet to the fire?
No.
Henry, what's your opinion?
I wonder if a plat note might address and bind any future purchasers to it. I believe that it would, but we would have to have the agreement of the surveyor in order to put that on there.
I think that unless the surveyor has the limited power of attorney that is required by this body, I don't think that the surveyor can bind the property owner to anything. And I think that there has to be an affidavit, at bare minimum, there would have to be an affidavit of J Max LLC stating that he agrees to be bound to that before such a restriction could be placed on the plat, because the owner has to sign the plat.
I understand. All right, thank you for your comments.
See, Mr. Ruby, you got an answer out of me.
It depends used to be my go-to, and I don't like that I used to do that.
I know, but as I'm sure you also used to encounter,
It
if
really
you're
did
being
depend.
held to your professional standard, you want to be sure you're given the right answer.
Well, and he was very good at making sure he had two lawyers' opinions.
All right. Thank you all for your time, and
Thank you.
again, if after hearing from anyone else, you all have any further
Right.
questions, I'm happy to address them to the best of my ability.
So we're still in public hearing, and before we get to commission comments, I think we need to hear from anyone here from the public that wants to speak. I'd ask you to please, again, limit comments so that we're not hearing repetitions of the same thing, and noting that Ms. Thornberry has done a good job of representing the issue. If you wish,
For and against? You gonna divide?
We got somebody
Divide
wanting to
for and
comment.
divide against?
I'm,
We're
ass-
against
I'm,
already.
yeah, I'm assuming we're into against already. So, yes, if you need to speak, you have to come to the podium, give us your name and address, please.
My name is Claudia Fisher, and my address is 155 Weatherburn Court, and my property is directly behind where they're putting the houses. I've lived there 33 years. We built the house, and the first year we were there, we had a rain that was 7 inches in a half an hour, and our property slopes down, and the backyard filled up 4 foot, because my husband had planted a 4-foot pine tree, and you could just see the top little bit of it. So there is a water issue. And I just wondered if there's any plans for the watershed, because my husband always worried with just one house there that we might have a problem. And I did bring some pictures. Would you want to see some pictures of how?
I don't think that's
No,
necessary at the time.
I think that if we ever got to the point, if this ever got to the point where there were houses there, that would be required under the site plan.
Right,
Yes.
the site plan definitely looks at water flow shed, and of course, everybody here knows Boyle County's a nasty water flow.
Well, and already the developer has, there's a wooded area between my house and where those houses will be. And he's already taken down probably half of the trees. So with just that, I'm probably going to get more watershed, I would think.
But
Because-
including your comments, and that's what we want to have them recorded, it's one of those items, as Tom's alluding to, the site plan, when we get to that, or
Okay.
when it shows up, has to address those issues.
Okay.
So knowing that it's concern is a big factor, thank you.
Yeah,
How will I
thank you.
find out when to come for one of those meetings?
Ms. Thornberry is gonna let you know.
Yes,
Okay. Okay, because,
right.
you know, and I had hoped to have pictures from this year, but it's been very dry, so.
Yeah, thank you.
So, I don't know yet, I'm kind of sweating it out.
All right, thank you.
Thank you.
Thank you. Next, I saw a hand. If you wish to speak, you need to come to the microphone, please. Yes, please.
Good morning.
Morning.
I don't do good at public forums.
We need your
But
name
I
and
want
address,
to-
sir.
I want to express that I thank
Need
the
your name
commission.
and address?
Your name and address.
Jim Lavelle. I live at 146 Colonial Way. And so thank you very much for taking public comment. When I moved to Danville, I moved here because my mother lived here part-time, and I wanted a good retirement community. The subdivision that I built in was to be a good retirement type of subdivision, and the integrity of the neighborhood is somewhat of a concern. There's also, in a separate item, but kind of associated, the egress from 34 onto Lexington Avenue is very confusing. There's an S turn by the church, and nobody uses their blinkers at that site. And between 4 and 6 p.m., you can't get across there without a long delay because the stoplight down at the bypass lets the cars through, and there's about 200 feet between each one of them. So I think any additions to the community should consider the traffic flow there, and multi-type residence is not really what I think we should do. And I moved there, paid a lot of money for a house built, and I like to have the neighborhood stay that way. Ms. Thornberry did an excellent job. I'd like to thank you all for your comment, and I'll leave it like that.
Thank you, sir. All right, anyone? Yes? Take your time.
My name is Josh Will. I live at 131 Colonial Way. I'm in Section 6. And I think there were some really, really good points that I'm not going to try to belabor here made before. The one comment that I did hear earlier on was that they think that it is congruent in size to other houses, and I think that that's a speculation. And I think that Mrs. Thornberry made a lot of things that give you guys thought that probably shouldn't make a decision today, but that's my opinion. But certainly speculation on terms of congruency to the rest of the neighborhood should be researched prior to just, I think so. So that's really my point, is that it's not across the board, and the neighborhood differs and the Section 6 differs. And so I would encourage you guys to take a look at that before making any kind of decisions on this today.
Okay, thank you. Anyone else here wish to speak? Yes, ma'am.
I'm Gail Lewis. I live at 125 Colonial Way, which is almost directly across from the proposed changes. And I would like to say that we keep talking about a 5-acre plot, but if you drive up there and look, you'll see that over half of that is not buildable because it's a sinkhole. It goes directly down to the property that Ms. Claudia Fisher referred to. So you're not talking about even 1/4-acre lots. Furthermore, I don't know of anybody up there who has a 1/4-acre lot. Most of them are a half. Mine is just slightly over a half, and it's one of the smaller ones. So there is no way that 7 family units could be built on that property and not destroy the property values of all of us up there. We have a very nice, very desirable community, and I want it to stay that way because, as Jim said, I paid a lot for my house, and I want it to stay and keep that value. And the traffic, again, would be a nightmare. That is a cul-de-sac and no outlet, and we don't want an outlet. But consider that is not a usable 5-acre tract. Thank you.
Again, any other comments? Here.
Good morning. My name is Janet Humphrey Cole. I am an attorney. I do not do real estate and planning and zoning, so please do not ask me any of those questions. I come to you today because I'm also a resident on Colonial Way, almost directly across the street from where this is intended. So I do want to speak to a couple of things that I heard. I know that today you were here to decide whether or not to put this into 5 or 6 tracts, whatever it is that they're being requested, and to decide whether or not that is technically correct. My concern is that you've heard some of the comments that not all of the space is going to be usable. But I want to remind the committee that, in fact, this was originally set out as a green space. So this was not really ever intended to become what they're asking you to do. And so if there is any possibility that what JMAX can do with this property at some point in the future is to make this multifamily units, that is directly in defiance with what was always intended for this space. So I would ask the committee, or ask the body here today, to take some time to decide what is going to happen with that space and to give us any amount of reassurance as to what might be coming into that space. But if it's anything more than a 1 or 2 family unit, I don't think that that's going to be something that's congruent with the neighborhood. This is the cul-de-sac. Everybody talks about it. I live on it. People come and walk their dogs. People teach their kids how to ride bikes there. So if we're talking about bringing in substantially more structures, you are going to have significant traffic issues. You are going to have potentially water issues. They exist there already. But if there is any ability for us to know more about what is going to be going in there and whether or not that's appropriate, Ms. Thornberry brought up whether or not the covenants even allow such a thing to be made. I would implore you to take your time with this decision, given the fact that there is a lot that could flow from it. I understand that one comment was, this is only to approve the tracts. Well, let's be frank. There's no need to approve 5 tracts if they're not intending to put new structures on those plats. It could stay as it is. So to say this is only to decide those tracts, no, I don't believe that's correct. You're being asked to make the first initial decision about whether this 5 acres is going to become homes to 6 or 7 families, or whether it's going to remain the green space that it was originally set out and designed to do. So I would implore you to, 1, take your time with this decision, and 2, to have far more information than what it appears you have from either the JMAX or their subcontractors, engineers, those are things. So I would just implore you to take your time with this. And if you want to know whether or not making 5 or 6 houses there, potentially multifamily residences there, is congruent with the neighborhood, come on out. We are happy to have you drive through. I understand that the houses in that cul-de-sac may have smaller lots, but the lots that you're going to drive past to get there are not consistent with half-acre or even quarter-acre lots. So I would implore you to just make the drive. It's not that far. It's, I think, 7 minutes from here. I would implore you to get a sense of the community before you agree to allow it to be subdivided into different tracts. And again, with the bare minimum amount of information that I've listened today that you have, I would just implore you to take your time and make sure that we have any sort of additional information that may be required or necessitated. And there's no need to put in 5 tracts if there is in fact a covenant that says this plot or this tract will only be home to 1 residence. So again, thank you for your time today. I understand the importance of your decision, and I hope you have all of the information you need to move forward on that. Thank you so much.
Anyone else wishing to comment? Please.
I'm Harry Nickens. I live at 107 Patrick Henry Court, which is within the subdivision that we're speaking of. There are actually 3 main streets: Colonial Way, Patrick Henry Court, and Raleigh Court. We've heard comments, and the attorneys are both presenting excellent comments, but the last speaker lives in the subdivision. It's a quality subdivision where your kids can get out and ride their bikes, or now we're being taken over by something called golf courts with 10 and 12-year-olds on golf court in a safe subdivision for them. But let me give you just a perspective of what I do not see happening on these at least 6 tracks. The largest one is really a downhill waterfalls in the making into a sinkhole, not a legitimate natural sinkhole is in that property. And it fills up and gets into Miss Claudia's backyard. But beyond that, how can a developer in any way complying with the quality of the structures and the neighborhood itself, how can on those 6 parcels, any one of the 6, I'm going to give you some addresses and values of selling for those properties. Colonial Way, 137, 4,962 square foot home. On the market, $725,000. 147 Colonial Way, $706,000. Go to Raleigh Court, 5,718 square foot home on it, 1 street below this, listed at $779. 85 Raleigh Court. That house is on the market. This one is a Zillow listing at 85 Raleigh Court, $651,000. Go to the street I live on, Patrick Henry. House sold, they occupied December 17th, $630,000, 5 beds, 4 baths. House on the market right now, $659,000, 108 Patrick Henry Court. There's no way on these small tracts you can construct new housing that's consistent with the neighborhood. And all that, well, we're taking care of our investment, as Jim pointed out. But it's the quality of the community. When on Easter, we go to one property on Colonial Way, and decorate for Easter the cross with flowers cut from the backyards. When you go 3 different places, you go to one home for hors d'oeuvres, a second home for a meal, the third home for dessert, and the neighborhood's invited. So I would, and I've been on, not in your position, I spent 21 years in an elected position in another state, having to decide difficult decisions with people for and against whatever we're considering. I would just ask you, one, to visit the streets, look at the property if you haven't done so, because you need to get a real sense and feel for who that community is. Thank you.
I got a question, White, before you walk away. Are you suggesting that don't build anything?
No, sir. I think that, well, as the last speaker before me, that was forever going to be a green space, a park for the 3 streets in that subdivision. And all of a sudden, we hear it's going to be on the market now for development.
Okay, thank you. That's what
Going from a park.
It's an important comment.
Thank you.
Thank you.
All right. Anyone else, please, before we close out? Yes, sir.
My name is Les Letton. I live at 126 Colonial Way, which is directly beside this track. I'd like to ask you all, as the members, how many of you have driven out and looked at this property? Well, that's good. Y'all done pretty good, better than I thought. Obviously, then you know what a terrible piece of land that it is. And you know that the original developer, which ended up in the hands of Steele Gregory, they knew how bad it was, and they didn't want to have anything to do with it. If it had been a nice piece of land and it would have been developed to start with. So I've been there around there for 40 years and lived in that subdivision in 3 or 4 different houses. And I've always known that there was a restriction on that piece of land, that there would only be one house built there. I would not have built beside that piece of property had it been open for development. So I think it's pretty obvious, if y'all are here to protect the community and do your job, then I appreciate your interest in letting everybody speak today. And I'd like to ask everybody that lives in that neighborhood, if you would just raise your hand if you live in the neighborhood. Okay. All right. Thank you very much.
Yeah, thank you, sir. All right, anyone else? We close out. Any speaking for? Yeah, we should ask, yes, is there anyone who wants to speak for? And we've heard against. Very good. All right, can I have a motion to move out of public hearing?
So now make the motion, we move out of public hearing.
Very good. In a second. All those in favor? Thank you.
Sorry, can I make one comment, if I may?
Yes.
So about the size of the lot. So I just want to kind of go down each one across the street and just kind of tell you the size of the lots to kind of just address the character of the size of the lots or whatever. So immediately next to it, it's 0.20 acres, 0.23 acres, 0.1 acre, 0.18 acres, 0.121 acres, all the way down to Colonial. The first house that is bigger than 0.28 acres is 3.38 acres, and I believe it was somebody who spoke today. But generally speaking, this neighborhood sits on, like even Raleigh Court, 0.53 acres. Patrick Henry Court, 0.38 acres. So directly across the street, it is smaller because it is zoned RM3. So most of those lots directly across the street is 0.18 acres, but most of the other houses down Colonial Way, zoned R1A, are sitting on a half-acre lot or less, generally speaking.
Thank you. All right, so I think we're at the point where we need to discuss questions from the commission or any issues that we want to bring up before we talk about what potential actions we might take. So are there other questions that the commission needs to hear or questions that we need to direct to our council?
Yeah, I think we would just direct the questions to the council based on what he's heard, what our options are to proceed.
I had one question technically for procedural requirements. We elected to, as a commission, to listen as a public hearing on here. It was not advertised. Is that something we have to do?
I don't think that it is. A public hearing is not required for subdivision plats. The applicant was here by virtue of engineer and had the chance to hear everything that was said, and I still don't think there's any requirement for subdivision plats to have a public hearing.
And I generally agree with you. I state this because these folks come because they're certainly a big interest. By not publicizing it or telling other characters, we've had a conversation without other residents making comments,
Well, and
whether
yeah.
that's a concern or not.
I think we need to acknowledge that we chose today to open for public hearing.
Okay.
And to take comments, which were not required in the context of what we're being asked to decide, but everyone's here, and we wanted to do that and make sure everybody got heard.
And I agree, because the reflection that we had is, having been at the tech meeting that we had earlier today, or earlier this month, which is I regularly attend an arrangement, we have more information that I didn't have during that time period. We've already heard the information on there. And it would be nice to follow those topics to ensure that that is exactly, and have feedback on what that means in the big picture.
All right. So can I ask if there are other questions on the commission? It seems to me we have options. Certainly before us, we can choose to approve the plat. We could choose to table this issue and send it back to tech committee, or we
to
could.
the applicant.
Hmm?
Or to the applicant.
Or to the applicant, right? To modify the proposal. Hannah, let me ask a question around the split zoning, because that was one of Ms. Thornberry's issues. Other zones in the county are split zone, is that correct?
That's correct.
And we're not requiring all of those to be amended today, is that right?
I don't believe so, no.
Nothing in our ordinance or subregs requires a particular action with regards to split zones. It's a complication for the owner, but it's not one that we are required to resolve.
Thank you. All right,
So, if I could recap here a little bit. So it sounds like, to me, that when this was presented to tech review, they're looking at the plat, the setbacks, and so on. And with that information provided, this is technically correct, and therefore be approved. However, you did not have the information relative to the deed restriction that says this plat can only have one
And
home on it.
that was added on, the comments that are on here were added after the meeting.
And added, okay, so
we
added
do-
after,
They were added to it.
after tech review.
But-
So
But it's,
I agree with comments, sorry, forgot the name the lady made about it is unreasonable to think we would do dividing into tracts if the intent wasn't to build something on each one of those tracts. Therefore, I believe I would recommend sending this back to the applicant to say, you can't do this unless you get the unanimous vote of the partnership, and he can deal with the legal mess that may, right now, with it being the LLC or whatever. But that seems to be the body that has the ability to say, yes, we can you can do something other than the deed restrictions that are in,
Like, if he came back, if we sent this back to the applicant, and the applicant came back and said, sure, I still want to divide this into 7 tracts, or I'm only going to build on one of them, I'd ask for them to tell us which one they want to build on. Okay? And make that within the, I mean, I don't know if we can legally allow them to not sell small parcels that can never be built on, because that's, you know, I don't know if we can't, if we can't allow that.
The one other topic
My
that
point-
was said was the understanding this was all green space, but it could be green space on individual tracks.
Yeah, I mean, listen, what I want to get to is, okay, I have 2 questions. One is, okay, could he decide, could the owner decide that he wants to put a multifamily in there? Because because the zone, you know, goes across the property. Okay, there's 2 zones on each of these. Each of these 7 have at least some part of it that touches the RM3.
I believe the deed restriction would restrict that.
Okay, so the deed restriction would,
So according to
Right.
the deed restriction as it sits,
there can
there
be,
can only be one, and it's got to be residential, it can't be multifamily.
it has to be a single family.
And I agree, we need somebody who's got a different, more legal perspective on that to make
But-
sure we confirm that.
But all
Right.
of
That's
those,
only on one track, though.
That would only be on one track, so that
Right,
would
that's
be
the
my,
only restriction.
right, and so the way that this is presented to us with the setbacks, it is not presented to us as, well, we're just gonna let them sell it and let the people figure out that, no, this is intended for houses. Okay? I would really like to have this come back to say, or no, I would like to send it back to them to say, hey, can you please address these issues of the deed restriction?
Sorry, if I may make a comment about that, we did discuss the deed restriction at tech review, so I do want to just make that clear that it wasn't, you know, not there. It wasn't, like, we knew about that at tech review, but we asked them to add that comment to ensure that it was legal and all our.
And the
yeah.
historically, we have lots of plats that have deed restrictions
Yes.
of multi-zoning on them. Not restrictions, but multi-zoning on them. We just allow them to exist. Are we, and I'm not sure that we're intending to change that
Right.
thing either.
exactly. So, Henry, can I ask, are we allowed at this point to send this back to the applicant? Is that one of the options that we have before us?
It is an option. We, by my count, have to decide up or down on this by about July 1st. We have 90 days to address plats submitted to us, or else they automatically are deemed approved.
Let me ask you this, Henry, could we make a vote that says this would be disapproved unless the applicant comes back within the 90 days to address the issues that we've discussed today?
I'm not sure
we
what
can-
that vote stands for. I think we can send it back with that admonition, but a contingent vote of disapproval is something we've not done before, and
I would think-
I'm
I
unsure how
think
it would work.
disapprove it right now. We would have to disapprove it right now. And then recommend we send it back to it. You can submit it again later.
Well, even a disapproved vote, we would, and here's why,
Yeah.
right?
I
And
think
he
that's-
can, and then they can do it again once they fix that.
That's the way I think.
We could
Is there-
disapprove it. It's not totally clear what authority we have to disapprove it. I think possibly
that's the-
the cleanest thing would be to postpone it and say, please, applicant, fix these issues.
Exactly. I want to be clear, as long as the technical requirements are met, we are required to approve. We cannot disapprove at
Right.
this stage. So the option to disapprove is not one of the options we have here.
I do not think it is, while I understand Tom's point of, hey, we can't, the guy's got his land, he wants to put it in different parcels, he can't pick who builds on it or doesn't build on it. I think we're setting up a future homeowner as having problems, right? They'll put these on the market, I would assume if I'm buying one of these lots, that I can build my house on it. And let's say I'm the second guy in line to do so, then I go to get my building permit and it comes back and says, well, no, this is part of parcel 2 and you can't build a house on this lot. I've just paid $20,000 for a .2 acre piece of ground in the county or in the city.
You're-
I don't think that's, anyway,
what I want.
that's my
Yeah.
The
concern.
site, the site plan activity, you've got a point here, but the site plan activity, where you place it is,
But
Is
if
there
I'm
topic
buying,
downstream?
if I'm buying the property, I'm not doing a site plan before I actually own the property.
it's-
And so you're setting people up to potentially buy something that they're assuming they can build on. And then they would get there and they'd say, nope, sorry, you can't build on that. And I don't think that's a
We don't want to be that
good place to put it.
Commissioner
The other
Farr,
question- The other question I have, Henry, is so we mentioned, I heard mentioned several times about being a green space. We haven't seen the final plat amendment of the Williamsburg Village and Rolling Hills Meadow, Section 6, blah, 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 in here. If that calls this out as green space, does that hold any water?
if that plat says this shall be green space forever, then that's a restriction we would want to consider and probably abide by. Have we seen that plat?
So
think-
this
Previous
is
plat.
this is the
Yes,
plat as
it's in-
amended, right? But in the original plat,
For that lot.
does it say that this area is green space or potential future?
Has everybody
Garden
just
neighborhood.
understood it to be green space, or?
That was
or-
the,
Yes,
Okay,
that's the question.
that's the point, like, even if everybody understands it to be green space, if that's not in the deed, then we can't,
well, it
we
was
can't
the
act on
zone.
that.
The zone previously to RM3 was NCC, so it was Neighborhood Conservation Commercial. So it was designated green space by our designations. Good in theory, not in practice, but I don't know about the deed restriction. But the old plat is in this packet that Ms. Thornberry gave.
is the,
So I
is-
just
is
want
a-
to acknowledge as chair, we're not taking comments. Thank you. And to this point, now, what? Sorry. Oh, I'm sorry. I'm sorry.
the surveyor. It's different.
To answer this question.
Yeah.
Thank you.
Thank you.
I just wanted to provide some clarification. The original subdivision plat that created Section 6, Plat File 852B, did have a portion of this property zoned at, it was, sorry, not zoned, that's what she used. It was designated as green space. A later plat, 1804, I believe I noted, it abolished the green space. So that is not, there's no confusion. It was at one time designated as green space and later abolished by the developers, and the lots were changed. So I just wanted to provide that info.
Thank
There
you.
there was a zone change in the 80s to make this a condominium lot. As far as I know, I have a written agreement with planning and zoning. As far as I know, that just kind of went by the wayside, but that was also something that happened.
Mm-hmm.
That's not what we're seeking, but just provide as much info as I can
Right.
on it.
Understand. Thank you. All right, so given that our options are to approve or to table and send back, do I have a motion in front of the commission? Or do we have other discussion we need to do?
There,
I apologize if this is out of order, but I would like to ask Mr. Smith and the commission if I could address specifically the history that has been mentioned here, because I
Well-
have copies of all plats and how it relates to the deed that you all have in your packet, and I did
Well-
not include it originally.
Can I ask you to hold, please, till we talk about what we might be able to do here? My sense is
it needs to go back to the committee. It needs to go back to the technical committee.
well,
your
so
microphone
as chair, I'm looking for a motion from the group where we can talk about then, what do we do?
I guess I would propose that we decline the plat as presented based on the deed restrictions.
I'd like to send it back to the committee, for the tech committee, and have that information collected and reviewed by whoever and presented back.
So, to your point, I think we cannot disapprove.
It does not meet the requirements in the restriction.
The deed
It's,
restrictions
this is,
are not-
I just want to, I'm so sorry, but I just want to reiterate the comment that we are here for a subdivision approval.
Yes.
If it is technically correct, we are required to approve it.
Yes.
I'm questioning whether or not it's technically correct.
That's my question
I'm
as well.
questioning whether or not it's technically correct. It's presented, it is presented to, it is presented to us as 7 buildable lots. Okay, that's what's been presented to us, is 7 buildable lots. I don't want to pretend that it's not presented as 7 buildable lots, but 1 lot and then 6 that can be just sold for people to do their own gardening. I just don't, I don't want to pretend that that's what this is. It's presented to us as 7 buildable lots.
So Mr. McGlone added the plat note in the language that I suggested to him, which says, look at these restrictions, you might want to talk to an attorney. If you have further language that you would suggest adding to that, we can contemplate that for a month, or you can suggest it now. And maybe that language would look like, these deed restrictions say that there shall only be 1 structure built on this. We could have, in other words, the explicit restriction printed on there as well, and then say, talk to an attorney.
Yeah, like if this came to us with the deed restriction on there that said 1 buildable lot, but we're going to put 7 up for sale, then I would say, man, that's a public record right here. If you went and bought one of these lots after the the first home was put on there, then you ought to know that. But that's not what's being presented to us.
I think we're within our rights to ask that it be presented to us that way. I would just say that rather than us taking the position of printing that restriction on there and saying, you must abide by it, I suggest to you that we should print it on there and say, consult an attorney to discuss this restriction.
And you're leading to sending it back to the committee, or the tech review group?
If that's the pleasure of the planning
And
commission.
I agree with that.
Yeah, that's not our council's decision, that's our decision of what we do. So I'm still looking for a motion to either
Are we
send this back or to approve.
I'd like to
Those
make
are
a
the-
motion.
Those are the actions. in
Are
front of
we in legal jeopardy if we just disapprove this?
I believe that we could be.
I'd like to make a motion to have this topic sent back to the tech committee to address and resolve several of these issues.
All right, we have a motion. Do we have a second?
Mr. Chairman, we cannot hear you all speaking. You're not speaking into the mic.
Oh, sorry,
All of you,
sorry.
all of you. Mr. Collier, we cannot hear you.
I don't know how much closer I can get. The microphone's on, please.
I would suggest that maybe the public consider moving up to some of these vacant seats in the front row. This system is the best we can do.
I apologize, but there's nothing I can do about it. I do want to make a motion to send it back to the tech review committee.
All
It
right.
needs to ensure that these topics
So-
are here.
So to reiterate, Mr. Collier's motion is to send it back to tech review and allow that committee to assess all of the things that we've heard today.
Pull it back together and then present it back to this committee.
Mr. Griffin, are you? Yes, second, do I have a second to that? All right.
Why would we not send it back to the applicant rather than the tech review?
Well, the tech review provides the provision that it goes back to the applicant will have to address some topics
Why we have to do that step? But we should send it back to the applicant?
by rejecting.
I'm,
We're not taking any action, we're just sending it back.
Right. I wonder what is the difference between sending it to tech review and sending it to the applicant, other than sending it to tech review builds in the idea of review by that committee. If we send it back to the applicant, I guess tech review could still hear it. It's just that by sending it to tech review, we are sending it to both the applicant and tech review.
Yes. We're sending it to both. All right, so we've had a motion and a second, and any other discussion or comments?
I'd like one more clarification on what the legal jeopardy is that we put ourselves into if we just deny this.
where 100.275 requires that we have objective standards that apply to these things. And I hear you, Mr. Farr, say that you don't believe that it's technically correct. The standard for technical correctness is not by deed restrictions, but by our subdivision regulations. And I don't identify anything in our subdivision regulations that this plat falls short of.
Okay, that's the answer that I was
okay.
looking for.
Right,
That's the legal answer that I was looking for.
all right. Any other?
No, no.
No,
we're done.
excuse me.
Harry, no, sorry.
I'm out of order, but we were not notified when the change from a park or what, green space, we as a subdivision, we were not notified of that. You think we would have not objected to that? You need to consider that when we see our green space disappearing.
All right, we have a motion on the floor with seconds. Any other questions? All right. Approve the motion.
We had stated, which sends it back.
We're
Send it
sending it
back.
back. All right, thank you. Can we read?
The motion was to postpone this matter for a month with the idea that the applicant revisits what was discussed today, and this body's technical review committee will take a look at it and hear whatever revisions the applicant can make. It will be heard then at the next meeting,
And
the fourth Wednesday in May, so.
The tech review meeting is the second Wednesday, the very
20
month.
27th, looks like, May.
And is the tech review meeting open to the public?
No. It's a limited space. We're in a small conference room.
All right.
There would be no comment at tech review.
Yeah, it's not, we're not,
All right, thank you. All right, we're moving on in the agenda. And appreciate the public's participation.
Chairman, how may we get a copy of what you all are considering? We need a copy of your document that's been quoted by you all. We have no idea. We don't have the details of that. But we're asking for a public record. At your expense.
I think,
We don't maintain that public record. We don't maintain that public record.
I think you need to ask your attorney to do that research, sir.
We can't get a copy of what you all
Isn't this
Oh,
online?
of this.
Yes, yes, this
You
is
can
also
look at it
online.
online.
This is online, yes.
including the revisions that were last minute to the commission.
No, not those revisions yet, but those will be online, in the meeting materials on our website.
All right, thank you. All right, we're moving on to now public hearings.
May I suggest a little break, water break?
Yes.
Okay, thank you. 5 minutes?
Yeah. Can we have a motion for 5-minute break?
So moved.
So moved.
Thank you.
Thank you.
All in favor, yes.
we have a tabled public hearing around the Dale and Lisa Coffey applying for a zoning map amendment.
Yes, so this application actually got rescinded. The applicant wanted to rescind the application. I kept it on the agenda just in case we needed to make a motion, but I just wanted to check with Henry. Yeah.
As long as it's been rescinded, do we need a motion?
It's no longer ours to make a motion. so.
All right,
So-
thank you.
Never mind. Okay.
Very good. All right, now we're moving to item 2. We have, before the Planning and Zoning Commission, considering text amendments to Article 1, 2, and 3. I think we're considering 1, 2, and 3 only today, is that right?
Yes, yes. So I sent you this in the email, and so the meeting materials, Article 1, 2, and 3 of the zoning ordinance is in that link that I sent you, but the advisory committee met, made a few changes, and Henry also made a few changes, including moving some of those sections from Article 3, I believe, into Article 1 into Article 3, and then Article 1 into subdivision regulations.
Yes.
So I've made all of those amendments from advisory committee. Those amendments are online for you all to view, and it's what I sent you. But just to kind of go over.
Can we generally walk through?
Yes,
for those?
absolutely. Yeah, so,
We're assuming that we've all done our homework.
yes, yes.
but-
I want to say how carefully, I'm impressed with how carefully our advisory committee went through these line by line. So I looked at it.
Yeah.
And it was really well done.
Getting into
Well,
the
and-
weeds very much, yeah.
And as well, I think the work that was done by this consulting company, the
yes.
ZoneCo, is actually very helpful because
Yes.
it's trying to make the regulation more readable for the public.
Yes.
And that's a very important objective in front of us. So please, if you
Yeah.
walk us through.
So Article 1, 2, and 3 of the zoning ordinance are the ones that I'll be requesting action on. Article 1 strengthened commissioner attendance requirements and added clear enforceable guidelines when governing bodies must fill vacancies. So when there is a vacant spot, that governing body shall fill that seat within 60 days, or we can suggest somebody, which I think will be a great way to have a quorum. And additionally, in that attendance requirement, we agreed that in a calendar year, if a member in the P&Z Commission and BOA Commission misses 4 meetings in a calendar year, so 4 out of 12, they would get recommended to that governing body for removal. And additionally, in those requirements, we added language that says that governing body can also recommend removal at any time if they feel that their representative is not efficient enough. And no requirements of removal, but all recommendations. So I feel like that is good language. But the requirements to fill the vacancies, that is the requirement. But the recommendations for removal, I think that is just good language.
So fundamentally, I was not aware that this group identified the replacement for the commissioners. Is that what you're saying?
Only after 60 days, that would be the case.
But even after 60 days?
Yeah, so
Statutory.
If the county, or let's say
Or the city.
Perryville, or the city, or Junction, or any of the 4 refuse to fill the spot, then
Oh.
after 60 days.
Okay, but so they've agreed to allow us to fill
That's
it.
actually a statutory requirement that we were allowed to do. So I really just relayed the statutory requirement from the KRS into
Yeah.
ours, just to let us know that we are allowed to do that by Kentucky state regulations.
We reminded the governing bodies that we will or can.
Well, and remember, these text amendments now go for approval to
Okay.
all 4 of these governing bodies. So if we approve what's in front of us today, they now will go to those bodies to get Hannah's.
But I believe they are
Explanation.
all in agreement that this is a good step in the right direction.
So and make sure I understand the other part that have confused me a little bit here. The conditions why we would let somebody go?
That would be if they missed 4 meetings in a 12-month.
It's not automatic.
No.
Consideration.
It's-
Okay,
yeah.
good. Because the way I read some of the earlier wording, it was it just automatically happened.
Right, I think that was the March amendments, and I
Okay.
believe after we
So
met
thank
again
you.
for the advisory committee, it was more of a recommendation and sending that recommendation letter, and so not required to be removed.
All right, thank you.
Yeah.
That's what I'm,
And I think that, you all know the concern has been to achieve quorum at times with this group, and as well, either that or to properly represent the city of the county and make sure that the representatives are here. All right, Hannah?
All right, and do y'all have any questions about Article 1 before I go on?
Hannah, just a small technical note, 1.12.3 talks about rules of procedure that these bodies are to adopt. And I would suggest that instead of calling it rules of procedure, we refer to bylaws. We have bylaws and they kind of serve some of that same function.
Okay.
So it's just a cosmetic amendment.
Okay, I will make that change. All right, any other questions?
Article 2.
Okay, so Article 2 updates multiple definitions, including new language for qualified manufactured homes and references to the 2025 comprehensive plan. It also incorporates that zone code recommendations to remove outdated, ambiguous, and enforceable definitions. And in the updated April ordinance amendments, I highlighted all the qualified manufactured homes just to show you all what has already been approved by you all. So if anything's highlighted, it was approved last month, so please just know that that is not what we are approving today. But yes, a lot of the Article 2 definitions really just incorporate those 2025 comp plan language that we added, including 30-minute village, tiny homes that we've talked about last month. But I can answer any questions of those definitions that you all have.
I had a question. You brought up tiny home there. Does it still talk about if it's not a principal home, what is it? If you read the lines and words in there, you'd have to get very specific. I apologize, I don't have that in front of me.
Sorry, let me pull it up.
For a definition, yeah. It's brought up tiny home, which was on a particular page of that. And it says this is a principal home.
Okay,
If it's not a principal home, what is it? What is, does a tiny home, is that a word that's used for ADU?
no, I believe it's just based on the size, per building code, state regulations, anything.
My question is, do we have it defined in our standard or in the Kentucky standards?
The Kentucky building code defines tiny home. Yeah.
Yeah. I just want to make sure it was, and I didn't go digging around. Sorry.
No, yeah, and I'm glad that you said that because I do want to add something to that definition to say unit equal to or less than of 400 square feet.
All right,
So I will
that's a
add
good
that.
way to add that to it.
Clarify that if we could.
There's also a topic in there about the 30-minute
Yes.
village. But you allow for a car and for driving and walking. When I drive a car 30 minutes, that's a lot further distance than when I walk 30 minutes.
Yeah.
Is that what we want to do?
Well, it's more just a planning theory that we incorporated in the comprehensive plan about the villages. So I just wanted to introduce the idea of what a village is and kind of
Well,
get the idea.
But I think our discussion in the comp plan was walk or bike,
Gotcha, okay,
Yeah,
okay,
I think it was
not
too.
drive.
okay.
Thank you.
Okay, do you want me to make that change? Okay,
Yes, please.
okay,
Take out the words or drive.
Yes.
okay.
It just had a car. It's. Okay. And yes, I did read your comments. Thank you.
I'm sorry, what word, or it was 30-minute village?
It's-
Did I spell out 30? I can't remember.
It's,
Just remove the or drive.
Okay, thank you.
Are there other comments on section 2? Article 2. Comments or questions?
now, my only other question I had on there,
Sam's done his homework, he's got pages of
I know
notes.
it.
Thank you,
I'm
I appreciate
sorry.
it, really, thank you.
RIPARIAN, riparian buffer zone.
Yeah, it's essentially like a swale or like a
Well, I'm fine with that. It's just, we don't, we didn't do any changes to the text that uses riparian zone? We didn't.
No, I believe it's in the comprehensive plan, though. I
Yeah, it
saw
is.
it, yeah. So I just wanted to make that definition because it's in our comp plan.
Okay, that's what I was going to
Yeah,
ask, because
yeah.
you're
I just-
defining a word that's not being used in any of our
Right, it's,
Article
although
2.
it's not being used in the zoning ordinance, it is being used in the comp plan, and I just wanted to make sure that there's clear definitions for all of our ordinances and plans, regulations and plans.
Does it have to be there?
Not necessarily,
I'm just asking.
but I'm open to that discussion.
It's just adding
Leave it alone.
definition.
I like putting riparian zone in there.
I think it just unifies all of our documents.
I just,
Yeah.
Okay,
I'm searching.
gotcha.
You left me on the computer too long.
No, you're
Sorry.
good.
Mr. Collier, I thought of the same thing, but what I think now is that we could have some regulation that relates to it later, and then this is already in there.
Yeah.
That's fine. Okay,
I
I'm
didn't
done.
see a reference definition of a pedestrian shed. I've never.
Oh, yes, and that was
What
a
is-
comment,
is that
actually.
like a watershed? Or-
No, it's like a walking, it's like a quarter of a mile or eighth a mile. It's basically a planning theory that just talks to walkability of a space. And that was a suggestion by the ZoneCo report, because we have pedestrian shed either in the zoning ordinance or I think the zoning ordinance, elsewhere in the articles, and it doesn't define it. But yeah, it's just, again, it's just a way to have data around, is a space walkable or not, so.
And for those of us who read, there's a lot of definition of
Yeah.
sign.
Oh, so many signs, yeah. Yeah, but we worked with, me and Joni, our historic preservation coordinator, worked with TSW consultants out of Lexington, and they were very helpful in updating and Dan went to that meeting, our public sign meeting. It was great. So we really are working on unifying our historic design standards with Joni and the DHB with our zoning ordinance definitions to unify that and just have it be more aligned definition-wise. Mhm.
All right, any other questions on Article 2? Then let's move to Article 3.
Okay, awesome. Article 3 added a requirement that zoning permits must be obtained before any building permits are issued. Building permits must now include the zoning permit approval number. And additionally, I reorganized the article to address all the zone code concerns about clarity, readability, and enforceability. This article really does kind of, it is a large update, but again, I wanted to kind of condense all of the items and make it more readable for the public, make it easier to understand. I believe Henry had one note, and so I've removed, since our last tech review meeting, I removed the nature of action. So although the ones that you all saw in the link have that nature of action column in the first 4 pages, that is going to be taken out. So just keep that in mind. And that's just because it was redundant and,
Right.
yeah, so, but all the other changes really were concerns brought to us by the county and the city about making sure that zoning ordinances or zoning permits come before building permits, because a lot of, we've had several instances where a building permit gets approved without understanding kind of, there's another layer of, oh, there's extra buffers that need to be there due to the zone.
So I just want to be clear with everyone, so that's the critical piece here, is to add that we will require zoning permits, and that zoning permits will come first.
Correct.
And then we go,
Putting that in the proper order. so
In the
that
proper-
people- So that people never come out and say, well, why was I allowed to build this house and didn't know that I couldn't put a septic system in it?
Oh, and actually, to your point, Dan, it does add residential permits for unincorporated areas. So we are adding that. Mhm.
yes. And the building permits include, the zoning permit includes the step-by-step.
Yes, correct, yes.
Which is, here's what I'm going to need, here's the other approvals that are going to be
Yes,
required
yeah.
in order to move forward.
And it's just more laid out to allow people to understand where they have to go next and try to make that process for them easier. Yeah.
So Darren was just asking, so like, in this plat that we had this big discussion on this morning, where would the catch be? And I would say that would be in the zoning permit. That would be, because Rusty would give him a building permit.
Oh, yeah.
Right, see, he'd give him a building permit, but the zoning permit is gonna stop this and say, nope, there's already been one house built on there. You can't have, you can't.
Well, I don't know if necessarily deed restrictions would be implemented in zoning permits, but that is a good,
No, I think that you better than that
Okay.
have to do that.
Yeah.
Well, that's why we're putting the note on the plat, so that
Right.
it's not just a matter of deed restrictions, but it says it on the plat for zoning staff to catch.
When we review the plat, how are we supposed to know there's a house on it?
When there's the plat note that says only one house on this property per deed restrictions, it then becomes incumbent on us to see whether there's another house out there.
All right.
Or at least to raise the issue to the, we probably want to check.
Are there other questions or comments on section 3?
I had one question. The table at the very beginning,
yeah.
data centers, is that an appropriate?
Sorry, what was the question?
The question had to do with data centers
Oh,
and the issues related to that is a very complicated subject.
um,
Timing is very complicated. Should it be added?
as far as,
Somewhere I just looked at the tables at the your notes and things at the very beginning.
well, I don't know if a data center would be added at this time, because in these, we're just talking about applications.
How about anywhere in section 3?
Mr. Collier, I think the place where we might ordinarily put something about a specific use like that is in Article 5, which has standards for specific uses, such as when we were looking at merchant generating facilities, that's where we had that. So I think if we want to deal with data centers, that'd be the place for it.
Yeah, I think we ought to
Absolutely.
point out that it needs to go somewhere. That's the only reason I brought it
Yeah.
up.
And
I
that's,
think in
yeah.
the discussion at the advisory committee, we're suggesting we're not ready yet to deal with data center. So it's, but it is on our
In
short-term
our heads.
horizon.
Yeah.
Short-term arising, I like that.
Yes. We see it in front of us.
To address the zoning permit concern about the deed restrictions, now that we are adding residential zoning permits, do you all want us to add a line that says something along the lines of that like similar to the application? It would say if there are any deed restrictions and/or just check this box and add it to the application for the zoning permit? Okay, I will add that as well.
Very good.
By the way, there was the whole section there about the manufactured homes and elements. That's very good. It's a good explanation.
I think so. The
That was back in section
remember,
2.
we approved the manufactured home section last meeting.
Right.
What about school buses?
That's a
Some of them living on school buses.
manufactured home.
Yeah. Are there other comments on section 3?
No,
All right.
I'm very polite.
So, other comments, you guys? Any other comments on section 3? All right. Can we have a motion to approve the changes for section 1, 2, and 3?
I move that we approve the changes to section 1, 2, and 3 pursuant to the updates that Hannah's making that we discussed today.
I'd like to consider we look at it again rather than approve it. Are you saying to include the comments or?
No, I'm
and
saying
reissue?
that we just approve it. We've been waiting to approve this for a while now.
If we're wanting public opinion on the final version before we go and prove it, more opinions, you have to bring it back here again
I don't think
before
we're
you
asking
prove it.
for public comment on this. This isn't a public comment thing.
Well, it is a public hearing. It's on our agenda as a public hearing. This?
It doesn't matter.
Exactly.
Doesn't matter whether they're here or not.
This often unfortunately happens with these text amendments, so, yeah.
All right. So,
We've got a motion.
we have a motion and we have a second. All right. And we know we can't resist. And we're making you read as we go along. Thank you.
Okay, Melanie Thornberry. And I stuck around actually because you all were covering this and I was interested in it since you see me so frequently. There was some mention just now about adding private restrictions. It was something you were going to add into the Article 3 that you're looking at. Could whomever mention that again? I
Sorry,
just
yeah,
wanted-
so we were discussing, Mr. Ruby had mentioned that, like, for the plat today, what would we do, because we are adding residential zoning permits, like, how would we catch that in the future? And I don't know if there is currently a catch for that right now, because we don't have deed restrictions in the application for the zoning permit. So I was just going to say, as we are updating the zoning permit procedures, let's add a line in there, kind of similar to the application today that says, you know, any proposed plat restrictions, property or condominium owners association covenants, master deed or restrictions if applicable, and just have them add that if there is something of the sort, so that we know that when they apply for the zoning permit, so that we don't have to do that research when they get a building permit. And so that's our hope, is to
So
catch
that would be under that section 3.2, which is zoning permits.
Correct, yes.
Specifically.
Yes.
Okay. Which is different than the building.
Yes, yes,
permit
and those got
section that
switched.
you've-
Yeah,
okay.
and those got switched in the
Prevent
amendments.
us from jumping to giving somebody a building
Mm-hmm.
permit where they shouldn't be able to build.
Right, you all have had some great conversation about that very thing. And then I was just wanting to make sure, so it's going into the zoning.
Correct, yeah.
Permit. Okay.
But in the
That
current
language
zoning,
would
Which
be
sort
in
of
the zoning
echoes
permit.
the subdivision regulation requirements that I had noted, so.
yeah. In the current zoning ordinance, building permits come before zoning permits, but we did switch that just to make it readable. We're just trying to make it as easy to understand as possible. So it's zoning permits, then building permits. But I added that language that we discussed in advisory committee about you may need to go to the health department first to ensure that this is correct, so.
Yes, and I really like that requirement that you all just touched on about in order to get a building permit, one has to have the zoning permit
Yeah.
officially obtained.
And approval number on that building permit.
Yes, that's excellent.
And within the zoning permit, it's going to tell you about deed restrictions and covenants.
Yes.
Right.
I commend you all on thinking through those things. Thank you.
All right, good, thank you. All right, we have a motion and a second on the floor. Can I have a vote? All right, thank you all. We have approved the changes as amended in this meeting. Hannah, we have tabled item 3.
Yes.
What is, that's what we're tabling for our future meeting with the section 4 change?
So table item 2 was the tabled items from last month, just the zoning ordinance. Tabled item 3 is just the subdivision regulations. So next month, it will be zoning ordinance, Article 4, and subdivision regulations, Article 2 and 4.
Yeah.
But today, those are the only 3 articles left for today to discuss. So,
All right, so do we need a motion to keep those things on the table for next
I
meeting?
don't believe so, because they're just discussions only. Oh, wait,
All right.
yes, sorry.
Thank you. Just being clear that we're okay. All right,
Okay,
moving ahead.
okay.
New business.
Oh, did
Mr.
you-
Chair, I'm sorry, always safe to make a motion. If we could have a motion to postpone those matters until next month, save on the advertising
Thank you.
requirements.
Sorry.
All right, continue to table. Can I have a motion to do that?
I'll make a motion to continue to table. I guess it would be what, Article 4?
Article 4 and
Those are
sub-regulations.
Joint zoning ordinance and planning, text amendments to Article 2 and Article 4 of the subdivision regulation.
Right.
Did you want to discuss those items at all? So okay, no?
No.
Okay, sounds
We
good.
do not.
Understood.
I'll stick, here you go.
All right, and second, thank you, Terry. All right, all those in favor? Okay,
Unanimous.
new business.
I've got nothing.
You have none. Advisory Committee, none. Budget Committee, none. Personnel Committee, none. Other new business, none.
Nothing.
Announcements, none.
I just want to remind you all that next week, we're having the big planning and zoning training day, so
Yes.
please feel free to come if you all need hours. It'll be at the Centerworks from 2 PM to 5 PM. It'll be a great time, so reach out to me, text me if you need any other information. April 29th, next Wednesday,
Wednesday afternoon.
Wednesday afternoon.
Afternoon.
2 PM to 5 PM. It's going to be a party.
And it sounds like it's very informative.
It will be,
I mean,
yes. Brian Howard is the president for Kentucky APA chapter, Kentucky American Planning Association. He is also the executive director for Owensboro. He was just at the Kentucky APA conference last week. He's very informative, so it'll be good.
That's the second floor above.
Yes, yes, correct. The hub, yeah. Mhm.
Yeah. Above the hub. Third floor. Take the elevator in the back. All right. Do I have a motion to adjourn?
Rita, you didn't jump on that one.
Rita,
What did you say?
do you have a motion to adjourn?
I sure did.
Thank you, dear. All right, do I have a second?
So moved.
All those in favor? Thank you.